I'm just going to briefly introduce Matt and Anthony before we move on. I'm excited to introduce them. It's always fun. They're great at these things. Both Anthony and Matt have robust practices that include employment law. I'm sure that many of you have, in addition to seeing them on the webinars, had a chance to work with one or both of them. They're great. Matt is a partner at our firm, and he focuses on human resource, free expression, constitutional, and administrative law. He's appeared at all levels of court in Alberta and also before the Supreme Court of Canada. Anthony is also a partner at the firm. He focuses primarily on all matters related to work and the workplace. He advises both employers and employees on in both the public and private sectors. So with that, I will turn off my video. You'll see me again at the end, and I'll pass it over to Anthony. Go ahead, Anthony, and a reminder, you are muted, so make sure to unmute yourself first.
Thanks, Christine. And I just want to repeat Christine's thanks to everybody who's attending today. You know, this is the third one of these we've done. We've had a few of you that have come a couple times, and you know, so we hope that that means that you found the previous ones useful, and that you'll find this one useful and helpful as well, particularly in light of the fact that with the exception of Calgary and Brooks, this topic is very timely as of today with respect to stage one of the reopening, beginning with respect to loosening of some of the restrictions with respect to what have been in place for COVID-19. I do want to be careful when I talk about loosening of the restrictions, because in many ways there's new regulations and new minefields that you're going to be dealing with in light of the fact that for many of you, you're going to be reopening operations or expanding operations. And so what we wanted to talk to you today is, you know, kind of as set out here, is I'm going to be going over the first two topics, which are dealing with what do you need to think about before and while you're reopening with respect to your employees, with respect to your responsibilities, both to your employees and to a lesser extent, I'll talk about to the public. So I'll be going over the various occupational health and safety guidelines that need to be contemplated and kept in mind while doing this. And then I'll also be talking about how to end a temporary layoff. We know that temporary layoffs were used by a large number of employers in order to maintain their staffing as best as they possibly could when there was no income coming in and no operations going on. And so as a result, as things start opening up, people are going to need to think about how to recall those employees and what are some of the considerations that need to go into that. Matt is going to be dealing with the last two topics and what I would call kind of exploring what the new normal is with respect to your employees. So the first half, I'm going to talk about bringing people back, and the second half, Matt is going to be talking about what is kind of the status quo that you need to consider, and also in what ways employers can use this situation as an opportunity to look at kind of the status of their employment contracts, to look at updating their employment policies, because, you know, when I say new normal, you know, I think it's important to keep in mind that, as I'm mentioned in detail, this isn't a matter of, okay, we've had a 2-3 month interruption, and now let's go back to the way things were in February 2020, because the medical officers have not said that that's what's going to happen, and there's no indication from a governmental perspective that that is going to happen anytime soon. And so it's time to think about the policies you have in place and your contracts in place on a go-forward basis. So with that, I'm going to go into the first topic with respect to occupational health and safety guidelines and best practices. As with our previous seminars, we are kind of just using topic slides, and I'll be going over most of the information as I'm talking, rather than very detailed slides. That way I know that you're at least partially paying attention to me, and I'm not just kind of talking in an empty room and nobody's listening. In any event, so it's important to remember all employers have a general obligation under occupational health and safety to protect the health and safety of their workers. And health and safety is broad. It includes physical, psychological, and social well-being. And it's the employer's obligation to ensure that their employees have their health and safety protected, and that any health and safety concerns are resolved in a timely manner. Well, what does that mean in light of COVID-19? Well, COVID-19 is a disease. It is something that jeopardizes your employees' health and safety. It threatens their physical well-being. And so as a result, you have to look at updating your health and safety policies in order to address some of these COVID-19 issues, and post these policies in readily accessible workplace locations, in addition to communicating them to workers, through other means. And so what do I mean by policies? Well, first thing you need to do as you're looking at reopening, or as you're looking at re-expanding operations, or just as you're looking at getting more public in as restrictions start to loosen, is you have to do a hazard assessment. And you may have done one, a full workplace one for your work site recently, back in February, January, but you have to do it again. It's a new hazard. COVID-19 amounts to a new hazard, so the workplace needs to be assessed, and you need to determine what are the potential hazards with respect to exposure to employees, to the virus, and do a walkthrough of the workplace to identify specific conditions, specific tasks that increase a risk of exposure. And in order to do this, once you've done your assessment, the next thing you need to do, and this is set out in the Occupational Health and Safety Code, is you need to design and implement controls. So step one, assess. Step two, you have to design and implement controls. Now, the Occupational Health and Safety Code has a mandatory hierarchy of the controls that need to be put in place. And I may sound like I'm becoming a bit heavy-handed with respect to, it's mandatory, it's a hierarchy, but this is what employers need to look out for, and what they need to kind of take active steps to put in place, because as you can appreciate from a political standpoint, the government in general is not going to want to get into trouble for reopening too soon. So they have put out various guidelines, and they are expecting them to be followed. And I'm sure that if they see any violations, either Occupational Health and Safety or the Ministry of Health, under its powers under the Public Health Act, will take steps to make sure that operations are shut down or at least suspended until these are dealt with. So with all that scare tactics done, the hierarchy of controls under the Occupational Health and Safety legislation, it starts with engineering controls. So first, you look at setting up engineering controls, so structural controls, to in order to eliminate hazards, or if it can't be eliminated, control the hazards. So what does this mean? Barriers, physical separation between workspaces. So if you need to rearrange floor plans, do so. The magic number is 2 meters. I'm sure everyone's heard that plenty, and it's in all the documentation. But insofar as it's possible, You want to redesign any bottlenecks in your workplace, any areas that naturally draw crowds, whether it's crowds of employees or crowds of customers. You're going to need to remove any communal items that can't be easily cleaned. A number of lawyers in my office are going to be very sad when they come back to work and find that the newspapers that we leave in the lobby are no longer going to be there, along with the Maclean's magazine. But those are communal items that can't easily be cleaned. And it's one of the engineering controls that our office is putting in place. It may go to the point of, do you have to look at your HVAC system and improving airflow with respect to that? Once you've kind of taken a look and said, okay, what structural engineering controls have we put in place, and can we put in place, and have we put in place, and are there still hazards? If so, then you also need to consider various administrative controls. Administrative controls are the second tier. Administrative controls are policies and procedures. So Matt, as I mentioned, will talk in more detail about different policies to consider, but specifically with respect to health and safety, do you need to look at policies that allow for freer work from home, staggered work days to reduce the number of staff in any location at a particular time, controlling number of customers in terms of, and to be clear, this isn't just, for example, what the government has said, for example, what restaurants have to do and what other organizations have to do. This is you looking at your operation saying, do we need to control how many customers we have in here in order to ensure that there's proper separation between people? Limit occupancy in unavoidable bottlenecks. So elevators, for example, have a policy with respect to people having to take the stairs or wait for an empty elevator. You may want to consider policies in place with respect to any tools or equipment you have. That there's no longer kind of a sharing on tools, or if the tool has to be shared between different employees, have a cleaning policy and protocol in place. One thing that should be in place, if it isn't yet, is you need to have a policy in place for isolating and quarantining individuals that show symptoms at work, that report to work while sick. One thing that we've been getting a lot of questions about are temperature checks. And can you do temperature checks? What would the policy look like for temperature checks for for individuals to see if they're running a fever, which is one of the most common symptoms? And the short answer is you have to look at what is reasonable in the circumstances. So are temperature checks allowed? Yes, but are they allowed in all situations at all times? The answer is no. So the reasonable circumstances, you have to say, okay, what's the hazard? Are they likely to get in contact with other people? Are they likely to contact something that will get in touch with other people? In which case, you may be able to do a temperature check, but you're going to have to look at doing one of the legal issues that comes to play when you're doing a temperature check, of course, is it's privacy issues. It's considered any kind of medical test of any employee is considered an invasion of their privacy. So you need to have a good reason to do it. It has to be reasonable to be doing it, and it has to be done in the least intrusive manner possible. I haven't seen one of those old mercury thermometers that goes into a mouth or somewhere else in a long time, but can't use those. If you do have one, use an infrared or a contact thermometer. Test should be done by someone who is qualified, has some training. At least, I would say at the very least, you should have someone with first aid training doing it if you have those in your position, in your location, and it has to be done in a safe manner. They should be trained, and they should show that they've been trained in the use of the device. One of the key factors is, as well, in terms of protecting privacy, is if you get a, if you get a normal temperature reading, then you, pardon me, if you get a normal temperature reading, then you discard that result. So only keep any result that shows that someone might be, that someone's may have a fever. In which case, you also want to have a policy in place that says that, if someone does read hot, you're going to discreetly talk to them and ask and advise them to leave the facility and seek medical advice. So that should be set up in a policy. Finally, if engineering controls and administrative controls don't sufficiently control the hazard that's come out of your hazard assessment, then you need to look at PPE, personal protective equipment, masks, shields, gloves. This is, going back to what I said at the outset, though, this is a hierarchy. You can't just default and say, we're not going to bother putting up plastic barriers. We're not going to bother, rearranging our workplace. Everyone just has to wear masks. That won't be sufficient to satisfy your obligations under the Occupational Health and Safety Code. And keep in mind that the administrative penalties regime under the Occupational Health and Safety Act says one penalty is for any violation of the act, the regulation, or the code. So you can't just go straight to masks. You can only use it after everything else has been done. If you are using PPE, you have to ensure your employees have training in that PPE. Don't just give them a bunch of pieces of Spider-Man cloth and say, okay, go make your own masks, and we'll see you at work tomorrow. You have to train them, have to give them the proper equipment. For certain workplaces, it also should be noted that there is a ministerial order in place that allows for additional respirators to be used at a work site. So if yours is a work site that has respirators as approved under the OH&S code, there's a ministerial order, Order 21-2020, that's 2/1/2020, that says you can do beyond what you're initially approved for. So that's kind of step one in terms of the broader, these are the controls, these are the things to look at. The government of Alberta, in what I think is a relatively unfortunately named set up there, the Biz Connect, B-I-Z. The URL is on the slide there. They've released earlier this week, they released a best practices guide that sets out a workplace guidance for business owners. I would recommend to go to this website. The website itself has a number of links. There's this general workplace guidance, which I'm going to talk a little bit about, but there's also guidance documents specific to particular sectors, disability service providers, health sector, homeless shelters, private municipal campgrounds. It's also got specifics to specific operations, so out of school cares, hair salons, museums, art galleries, outdoor recreation, retail, restaurants. So, and I'm not going to go into the specific details for each sector and each type of operation, but that is your go-to. And by go-to, it is not, these aren't generally suggestions. This is what I would say is going to be kind of the baseline for what OH&S is going to consider as due diligence. So you need to look at these steps to determine what you need to do for due diligence. So I do want to talk very briefly about some of the
Anthony, if I can just interrupt you, sorry, just for
absolutely.
a second. I just want to let you know, I should have mentioned this in the beginning. The links that you see on your screen now, you'll be getting those links in the email that we send you following the presentation. So if you want to go right away, you can feel free to scribble those down, but you'll also get the hyperlinks directly to those. And that's all.
Great. Thanks, Christine. Yeah. So now, as mentioned, the BizConnect one, there's a general guidance document that is generally applicable. And as I said, I think this is the defense to any occupational health and safety violation was the employer duly diligent? And so that's what I mean when I'm saying this is your kind of baseline for due diligence, is to go through. So some of the things it talks about is screening and implementing active screening with respect to your staff, volunteers, etc. It's, you don't allow anyone with any cold-like symptoms in the workplace. That is a strict prohibition. So the days of employees having a runny nose or a bit of a fever, expecting to just come into work and tough it out, you're risking a violation of a public health order and occupational health and safety if that happens now. So, you can't have that. Contact tracing is another thing that is recommended. So keeping lists, and this is going to be a bit burdensome for some industries, but keeping a list of the people in the workplace, who is on site at a given time, who's working a given shift. That's easy. The more difficult part is if the workplace has patrons, customers, contractors coming within 2 meters of employees, you have to list who they are, date and times that they had attended. This is going to be quite difficult for some businesses, but as said, you need to try and put something in place to hit that baseline of due diligence. Hand sanitizing station. I hope everyone bought stock in Purell back in 2019, because government's recommending you have hand sanitizing stations at every point of entry. And the hand washing, happy birthday 2 times, all that kind of thing. Increasing any cleaning and disinfecting protocols, including in terms of any public washrooms or any staff washrooms. Any gatherings in the workplace, there's still a restriction on keeping all gatherings below 15 people. That's still prohibited by public health order. That hasn't changed as a result of this reopening. And so you can have more than 15 workers in your workplace, but but you're going to want to forego any all company meetings where everyone's kind of in the same room or anything like that. If you have retail items or items being dealt with by customer, you're going to have cleaning protocols in place for that, more disinfection. And then home delivery is an option that should be considered for businesses that can operate with that as an option. So before I move on to the next slide, I just, I think that the key takeaways here are: do another hazard assessment if you haven't done one yet on looking for hazards related to COVID-19 based on the medical information we have now. Develop and update any of your policies and procedures to put in place these workplace controls. Remember that hierarchy when putting in these controls, and communicate any of these new controls, policies, procedures, to your employees in writing. And as mentioned, spend some time. The general workplace guidance is a 14-page document. If there's one that's particular to your sector or to your operation, take a look at that. Okay, so I'm now going to move on to ending temporary layoffs. So what we've done, as Christine mentioned, you'll be provided with a copy of this as well. But we've got a little checklist here. I'll get to the checklist momentarily, but I want to start with talking about, you've conducted a temporary layoff. That's pursuant to the Employment Standards Code, sections 62 to 64, and the Employment Standards Code specifically says what needs to be done to recall employees. Now, that being said, if you're dealing with unionized employees, recall, you look to the collective agreement first when doing recalls and look for any restrictions in there, and then you look to the requirements in the Employment Standards Code. The procedure is actually really straightforward. You have to serve them with a recall notice in writing. So you know, it depends on the contact information you have for them. But what you want to do is you want to communicate it in such a way in writing that you can hopefully have some record that they've received it. And the reason why is because the recall notice has to say a few things. One of the things it has to say is that the employee has to return to work within 7 days of the date of the recall, the date the recall notice is served. Otherwise, you know, after that 7 days, except if there's a collective agreement, then the employer may terminate their employment. Well, you have to be able to show that they actually were served the recall notice before you can rely on it. Date of service, just to be clear, is the date the employee receives it, not the date it was sent. So as mentioned, for best practice, you want to get some record that they actually have received it. If you're sending it by email, follow up and get preferably something in writing that they've received it. In terms of what order can you recall employees in? If they are unionized, you look at the collective agreement. Collective agreement will have a seniority basis, or it'll be silent on recall, although most of them, the recall is on a seniority basis, but the wording of the collective agreement will set it out in particular. If they're non-union employees, then there's no obligation to recall employees in any particular order, except for, you always have to keep in mind, you know, other considerations such as any human rights issues. For example, you know, you can't recall your oldest employees last because, you know, you think that you know, just because they're old, and even though you're not aware of any other risk factors or anything like that. So otherwise, aside from the typical human rights considerations, there are no restrictions on recalling non-unionized employees. Any order you want. If the employee fails to return to work within 7 days of getting the recall notice, the employer can terminate without notice. Again, this is for non-union employees. For union employees, often it's a longer timeline. It might be 10 days, might be 2 weeks. Look to the collective agreement. But before terminating, in those circumstances, there may be situations where the employee does not have to come back to work when recalled, and those situations may be human rights situation. So, for example, childcare obligations can fall under family status under the human rights, the Alberta Human Rights Act. And so, if someone is recalled but they can't come back because of childcare obligations, you may have, as an employer, a duty to accommodate them to the point of undue hardship. And an easy accommodation in those cases is, okay, we'll put off your recall date by a few days. Depends. It could also be, family status could also apply if someone has a dependent or is living with somebody who's at an elevated health risk. Again, they may be able to not come to work right away. Now, to be clear, accommodation does not mean they're put on a paid leave, for example. Accommodation, the saying goes, and many of you who I've worked with have heard me say this ad nauseum, but accommodation is reasonable, not perfect. So you're just going to accommodate what is reasonable in the circumstances up to undue hardship. But that duty to accommodate could also go back to those engineering controls I was talking about. Does that employee have an accommodation? Maybe that they have a desk, they work from home more. They have a desk that's separate from everybody else. They have different hours in order to avoid any possible exposure. They're away from anywhere where customers are coming in. Those are also considered accommodations as well. The other reason an employee getting recalled may be able to refuse the recall is under the Occupational Health and Safety Act. Employees have a right to refuse unsafe work. Based on the case law that we've seen with respect to SARS and H1N1, it is unlikely that the right to refuse unsafe work would apply when an employer can show that they are taking steps to, taking the steps required for reopening and following the guidelines from the Ministry for Health. So it's unlikely that that's successful, but it's certainly something that I expect that some employers are going to see, which is an employee saying, no, I can't come back to work. I don't feel safe. Those will all have to be dealt with on a case-by-case basis, because it depends on why they don't feel safe, and it'll depend on what the employer's done to ensure that there is no unsafe condition for that employee to return. Also, the employment standards COVID-19 leave regulation, that's the 14 days of unpaid leave. That's still in force, still in effect. And so all employees are entitled to 14 days unpaid leave if they're having to be quarantined or attending to family members as a result of COVID-19. But that's 14 days. And then it's not 15, 16, 21 days. So, but that's still there, that's still in place. And there's also, excuse me, Ministerial Order 18 that again allows for employees to take unpaid leave if they're required to care for family members or their child as a result of school or daycare closures. The other thing that's still in effect, that continues to be in effect, is temporary layoffs for a 120-day period. Now, one thing to keep in mind is under the old temporary layoff provision, you could lay off an employee for up to 60 days within any 120-day period. What it changed to was, a period of up to 120 days, and it did not include within kind of what period. Now, that change is only in force until August 14th, 2020, unless it gets terminated earlier or if the government decides to extend it. But right now, that 120 days leave is in force until August 14th, 2020. What that means is that you could put an employee on temporary layoff on August 13th, 2020 for 120 days. But on August 14th, when that no longer applies, then if you were putting an employee on leave after it expires, then you'd go back to the 60 days in a 120-day period. So anyone that's on a leave, even if that leave carries past August 14th, that leave would continue because that's the law in force when you put them on, not leave, temporary layoff, when you put them on layoff. So that leads me to this checklist that we've provided for you to kind of review when you're considering your recalls. Look at the contact information, make sure that any employment agreements, policies, collective agreements in place, the recall procedures there have been followed. Prepare written recall notices, has to be done in writing. And then the recall notices, one of the things that we recommend, you'll see in the third bullet down, advise of any salary or role changes. So one factor that may come up, and Matt's going to talk about in more detail, is that operations are not going back to the way they were in February 2020. And so as a result, employees may have a reduced role, may have a reduced salary, they may be coming back to a different job. Can you do that as an employer? The answer is yes, but. And the but is, some of you I've talked at length about on various issues on this concept of constructive dismissal. So if you have someone who was, for example, a receptionist, and you're calling them back to work, but you're calling them back and saying, yeah, but we're going to need you in the warehouse unloading trucks and doing heavy lifting, well then, in those circumstances, that's a completely different job. And that would amount to constructive dismissal, and the employee would not need to accept that. So can you change their salary? Can you change their role? Yes, the same you could for any other employee. So up to the point where it becomes considered a fundamental term, and it amounts to constructive dismissal. But otherwise, there is some flexibility there for different hours. The remainder of the checklist, as mentioned, some of these things you may not want to put in the recall notice. The new health and safety practices, you may just want to advise them that they're there and they'll need training on them when they restart work. But you do want to kind of give them some comfort that you're taking into account COVID-19 issues. And the other factor that you may need to consider is that they are obligated to inform the federal government of their recall once they're recalled, and that they should stop claiming CURB if they're getting employed, because as some of you may have read in the news, the government's not doing too much of a front filter. They're planning on getting anyone defrauding CURB or EI on the back end. And so some individuals who probably shouldn't have qualified have been getting money when they shouldn't have. And you certainly, as an employer, don't want to be seen as aiding and abetting any defrauding of Service Canada. So with that, I'm going to move it along to Matt. And as I said, he'll kind of talk about what to think about now once you've got your employees back, what your operations are looking like as they come back.
Great, thanks very much, Anthony. So one of the things that we're encouraging all of our employer clients to give some consideration to at this stage, before really you're ramping up a lot of your business and rehiring employees, is to think about employment contracts. So many employees will be coming back if they're recalled. Some of them will not. Some of them will have moved on. They may have received offers of other employment. And I've heard sort of a surprising number of employers saying that when they have been issuing recall notices, some of their employees are simply saying, I'm not coming back. So that means they may have to hire. That means hiring new employees. And so now is a really good opportunity for those of you whose organizations fall into that category to be thinking about best practices for bringing new employees on. The very best time to mitigate your risks arising from future layoffs or future terminations is at the start of an employment relationship. And what that requires is clear, concise employment agreements or offer letters. Now, you're not required to create a written employment agreement or offer letter. If they're not in place, the law will impose many implied terms into that employment relationship. So you'll hear of many instances where an individual says that they have, they're an employee of an organization, but there may not be anything in writing, or it may simply be a letter saying, we confirm this is your start date and this is how much you're going to get paid. In the absence of a written agreement, though, dealing with those issues, the law will imply some terms into the employment relationship. And one of the most important is the entitlement of an employee to reasonable notice or pay in lieu of notice upon termination of their employment. So that is a term that will be implied into all employment relationships in the absence of a contractual agreement to the contrary. And when we're talking about things outside of the union environment, because of course there you're dealing with collective agreements and it's a much sort of different approach. This is not to say that you have to have a long 8 or 9 page written employment agreement with your new employees. It does not have to look that formal. It can be simply an offer letter, but that offer letter needs to include some important terms as you're moving forward in these employment relationships. One of the important lessons from the pandemic for employers is that the flexibility that they had to make changes to their operations during the pandemic was based in large part on how quickly they could make adjustments in relation to their employees. So for many, maybe most employers, the biggest expense that they have in operating their business is employee expenses. And so long service employees, those individuals who have been in an organization for a significant period of time, they actually represent a significant liability on the books of the organization in the event that they need to be terminated. So for example, many organizations realize that in order to survive the pandemic, they would have to significantly reduce their workforce. Many organizations looked at the option of terminating employees as opposed to doing temporary layoffs. And one of the big factors that they had to consider was how much is it going to cost us to terminate employees as opposed to putting them on layoffs, which of course comes with its own risks and sometimes just a delayed payment of those obligations upon termination. And one of the realities for them was if you have a number of long service employees who have no employment contracts, then in some circumstances, it could be required that they would have to pay out months and months worth of pay in order to terminate those individuals because, of course, they didn't have the runway to be able to provide working notice of termination. So given the realities brought about by COVID-19, it may be necessary and beneficial to look at your existing employment agreements and templates and to look at how you want to deal with those moving forward. So for your existing employees, and that would include your employees who are on temporary layoff, but who you are going to be bringing back, remember that making a change to their terms and conditions of employment that would be considered an essential term gives rise to the risk of a constructive dismissal. So for those individuals, you cannot simply impose a change. You have to get the employee to consent to it. Generally speaking, that means you have to give them something of value back. That is something the employee is not already entitled to. So you can look at modest signing bonuses, for example. You can provide extra vacation time. There has to be something given back to them so that the changes that you want to make to existing employment agreements are going to be enforceable at the end of the relationship when you need to rely on them. This is very context specific, and so you have to do it very carefully with very specific wording, because you don't want to be seen at the end of the day when you try to rely on these provisions as having bamboozled the employee by slipping in restrictive provisions into the employment agreement without them really knowing about that. So what are some of the things that you should be thinking about adding to your employment templates? Now remember, as I said before, for new employees, the ones who you are going to be hiring who were not employed by the organization, it's the very best time to include some of these provisions in that agreement, because then you don't have to worry about providing some additional consideration or amending existing agreements. So here are some things to think about adding. Number one, add language with respect to the ability to put an employee on temporary layoff. So for those of you who have sought advice with respect to your ability to use temporary layoffs, one of the things that you would have been told is there is always some risk in doing this if you don't have a provision in your existing employment agreements that a court might determine that this was a constructive dismissal. That is a fundamental change to an essential term being imposed by the employer without the consent of the employee. Different provinces have different approaches to this issue, and certainly in other provinces, specifically Ontario, that risk is greater. There's been court decisions indicating that in fact that may be offside. In Alberta, we have a little bit more flexibility, but that risk is always there. So one of the ways to address it is to include in a new employment contract that the employer has the ability to require that the employee go on temporary layoff. And the easiest way to do that is to simply refer to those provisions in the Employment Standards Code to make it clear that that ability now becomes a part of the contract of employment between the employer and the employee. And therefore, in the future, if you need to actually enact one of those layoffs, you can refer to the fact that the parties agreed to that in the agreement itself. So keep in mind that the Employment Standards Code has very particular provisions, And for those of you who have been in these webinars in the past, we've gone over what has to be in those temporary layoff notices. Anthony has addressed today what has to be in the recall notices. But you need to be thinking about how you incorporate those provisions to allow yourself the ability to use them in the future. And as I said, the easiest thing to do is to simply refer to the Employment Standards Code provisions. What that also means, though, of course, is that if the Employment Standards Code is amended to change those provisions in the future, then you will be bound by whatever those changes are in the future, because your contract simply refers to the ability to use those provisions in the Employment Standards Code. If we have a government one day that deletes the ability to use temporary layoffs and removes it from the legislation, then of course that would no longer be available under the employment contract as well. And there are some provinces, for example, Saskatchewan, that did not have general layoff provisions in their employment standards legislation. The reason that we are encouraging people to do this is, of course, it was not common to have these provisions in employment agreements before, but we try to learn from the circumstances that we find ourselves in. And given the possibility, potential likelihood of there being a second wave of COVID-19 for your new employees, it will be useful to have those provisions in the agreement itself. So we hope that you won't have to use them for this purpose, but if you need them, they will be there and you'll be able to use them in the future. One of the issues that we talked about before is the ability for employers to rely on the doctrine of frustration. So that's a fancy legal way of saying that a contract can come to an end as the result of an occurrence that was beyond the reasonable contemplation of the parties at the time they made the agreement, and that renders the performance of the contract impossible. And it was certainly something that was on the table for employers to be able to say, look, no one could have anticipated something like this, and therefore it may be that the contract of employment was frustrated without the obligation to pay severance pay. There are lots of risks to relying on that, even right now with respect to the sort of this wave of COVID-19. But for future hires and in the future, it will be much harder for an employer to argue that frustration applies when you have a circumstance where we've been through this now and we know that that's a possibility. So in the future, courts may be looking in more detail at the contract that was agreed between the parties, and something like this may not be determined to be something that would frustrate the contractual relationship. So that's one, look at temporary layoff provisions, giving you the specific power to do that. Another one is termination language. Now, termination language in an employment agreement must be very carefully drafted. Employment agreements, which simply say something like, the employer may terminate your employment at any time without just cause by complying with provincial employment standards, that will not work in Alberta to allow you to terminate based on the minimum standards set out in the Employment Standards Code. There's a game of cat and mouse between employment lawyers and judges. Judges really don't like these provisions that tend to limit the entitlement to reasonable notice or pay upon termination. And so these clauses have been changed over time to reflect what courts will actually uphold. The language has to be clear and it has to be unambiguous. So what you want to have is language that is something along these lines. The employer may terminate the employee's employment at any time without just cause by complying with the minimum requirements for notice or pay in lieu of notice set out in the Employment Standards Code. The parties agree that their mutual intention is to limit the employee's entitlement to notice or termination or pay in lieu of such notice to the minimums required by statutory law, and that this represents the employee's full entitlement to termination or severance pay, whether arising under statutory or common law. Now, what you're probably saying to yourself is, okay, well, lawyers are clearly paid by the word, given how wordy that is. That is actually not true. We're paid by the minute. But the intention behind having something like that is to make it as clear as possible to a judge looking at this 15 years down the road that there was an express intention where the parties agreed that they wanted to use those minimum requirements, and that it would have been very clear to an employee signing on to an agreement like that, that that's going to be the case. that is much more likely to survive challenge. And what that means, practically speaking, in Alberta, is that under the Employment Standards Code, the entitlement to termination pay or termination notice, it maxes out at 8 weeks. So you have essentially 2 months that you would be required to either pay out or provide notice to. But under common law, that is those implied terms that will be found to be a part of the employment agreement in the event that there is no contractual provision like the one that I just read, the general cap on reasonable notice periods is up to 2 years worth of pay. So it's a significant difference in terms of how much it's going to cost you to terminate an employee down the road. And of course, when we're dealing with situations like the pandemic, where really employers had to be nimble and to be able to respond quickly, if they have employees with entitlements to very long notice periods, they of course would be unable to use the termination route if they may have to pay out 2 years worth of pay. So that is my biggest encouragement for people to look at their template employment agreements. Make sure that you're using the language that actually is going to be enforceable to limit those rights to pay in lieu of notice. It's one of the issues that comes up most often in my practice. And just keep in mind that when you are in Alberta, what I said was accurate. If you are in other provinces, there are different rules, and it's very important that you pay close attention to what those specific rules are. For example, in Ontario, there may also be an entitlement to statutory severance pay. So that's number 2. Number 3 is with respect to privacy. As Anthony talked about, there's going to be a bigger focus on occupational health and safety in the workplace. And that will attract privacy concerns because you may be requiring employees to provide you with information that would be considered private. So that can include information about their health. It could be collecting information about their health in the workplace. And keep in mind that the collection, use, and disclosure of that personal information has to be consistent with your obligations under either the Freedom of Information and Protection of Privacy Act if you're a public body, or under the Personal Information Protection Act if you are a private entity. And there's no doubt that information about a person's health or healthcare history is their personal information. So ideally in your employment agreements, and I'll circle back to this when we deal with policies as well, you will want to include a specific provision with respect to the collection and use of health information for those purposes. The collection must still be reasonable, so you have to ensure not only that you're getting the consent of the employees, but also that you have a reasonable basis for doing so. That will depend in part on the policies that you're implementing as a result of the pandemic, and you want to make sure that you're implementing good data storage techniques to ensure that that information is held in a secure place. It must be limited in terms of who has access to that information, and the use that is made of that information should be specifically set out in a policy. And you want to make sure that that information is not available on your intranet so that somebody can go and look at the information that someone's provided about their temperature, or if they had to quarantine, the reasons for that. So collecting and using that information for those purposes is important. And then, of course, disclosing that information outside of the organization has to be done in accordance with the law as well. The final thing to keep in mind with respect to employment agreements is the question of whether or not working from home may in fact become the new normal. Necessity is the mother of invention, and over the past 8 weeks, we have had the need to make significant changes in how people work. Organizations have made significant investments in infrastructure and technology to allow their employees to work from home. And it seems that many people, I don't think we can say all, but many people have settled into sort of an efficient and effective way to accomplish their tasks from home. And the question that we're getting from many individuals is, can we actually have that change be made permanent? So where it is working well for certain individuals and certain functions to have that information to actually be able to work from home, is it possible to make that change a permanent part of their job duties? So as with any change, as I've said before, you need to consider whether or not this would be considered a fundamental change to an essential term. If so, imposing that on an employee may create the risk of a constructive dismissal. But if the employee is willing, or if the employee is not willing, but you want to provide, notice of that change, then you need to look at what needs to be in place. So a remote work policy or a specific remote work agreement with the employee should be put in place if this is going to continue on past the sort of immediate impact of the pandemic. That has to clearly set out expectations for the employees. It should include considerations like technology. What devices can be used to access the employer system? Are you going to allow data to be stored on your employees' home computers? Bad idea in general. Generally speaking, you want to have people logging in through a remote desktop, but you want to deal with issues like how are you going to track hours worked? How are you going to deal with breaks and overtime? How do you monitor those people from a technological perspective to ensure that they are providing you productive work? You have to deal with workplace health and safety. So conduct a job hazard assessment for that employee's workspace in their home. That should include an evacuation plan. So you have the employee actually write out how they would evacuate from the home in the event of an emergency. And you want to contact your insurer to discuss whether or not your general liability insurance would cover work from home. As Anthony indicated before, you can give consideration to human rights considerations with respect to family status. And then finally, and importantly, you want to think about your WCB coverage. So when coverage is in effect, those responsibilities under the Act will still apply, even if the employee is doing the work from home. WCB recommends having a formal work from home agreement in place for employees who work remotely. That will make it easier for WCB to adjudicate claims that arise in the context of remote work. Generally speaking, the employee needs to be in their designated workspace during work hours for an injury to be compensable. So for example, if an employee develops a neck injury because they were not using appropriate ergonomic devices to work, then that's probably going to be compensable because it's an injury that arose in the course of work. But if the employee has a slip and fall as they're going upstairs to do laundry, or going upstairs to get another snack, I'm speaking from experience, then they are probably not going to be compensable because that's not something they're doing in the course of their employment. You should address drug and alcohol expectations to make sure the employee is aware that even though they're in their home, they're on work time, and therefore the drug and alcohol policy applies to them. And very importantly, in any work from home arrangement, you need to include a provision that specifically says the employer has the ability to cancel this agreement and require the employee to come back. I'm not sure if I said that right. The employer can cancel it and require the employee to come back. You want to make sure that you can have the employee coming back if it's simply not working. And that may be done on a couple of weeks' notice, for example, just to be fair in terms of the employee making arrangements in the event that you need to do that. So turning to the last section here, I know we're running a little bit over time, so I'll try to use my remaining time efficiently. Look at your policies. It's time to update them. It is a good opportunity for us to look at the policies that have been sitting on a shelf with some dust gathering. And if you're going to be updating your employment policy, make sure that you are advising your employees about the changes being made to those policies. Ideally, you want to get them to sign off on the policies, but certainly you want to at least get confirmation that the policy revisions were sent to the employees and that they read it. You can do that through email and requiring the individuals to sign off. And then you keep proof that that has happened so that in the event that you have to enforce the policy, you're not met with an allegation that the employee didn't even know what the policy said. Policies can also be a good place to set out your pandemic response protocols. Many workplaces did not have a pandemic response policy. Many workplaces are going to have policies dealing with these issues shortly. Those can deal with issues like self-isolation. Will you require employees to isolate even if they're not required to isolate by the CMO, for example? If so, for how long? Are you going to pay them to do that if they're not required by law to self-isolate? Will you allow them to use sick time or vacation time for those purposes? And then the pandemic policy is also a good place to talk about some of those things that Anthony addressed in terms of health and safety, sanitization procedures, personal protective equipment. And of course, much of that's going to depend on the nature of your workplace. But now is the time to start addressing some of those issues to ensure that you are well set up in the event that a similar situation happens in the future. Of course, we hope that it won't, but we have now had this lesson, and it is a good idea to start thinking about implementing those policies now. So that is the end of the presentation. I was only 2 minutes over. I'm sort of surprised. Thank you very much, and I turn it back over to Christine.
Sure, thanks. That was like lightning fast, Matt. That was great. I just wanted to close. I'll be very, very brief. I just wanted to say thank you again for attending and joining us today. We really do appreciate you taking the time out of your day to spend with us. Please reach out to us. You can see Matt and Anthony's contact info up there on the slide. If you have a question and you're not sure where to direct it to, send it to the client relations email that's also up there, and we'll make